So in this video, I want to talk about, I sat down and wrote, I was trying to review all my estate planning cases, and I made a list of 5 of the most common estate planning mistakes that I've seen in my practice, and I wrote a little list here. The first is thinking that a will, which is most commonly people think a last will and testament, which is the full legal name, thinking a will avoids probate. A will does not avoid probate. A living will does not avoid probate. A last will and testament does not avoid probate. A will does not avoid probate. Having a last will and testament is great. And everybody, including myself, I'm a young guy, I have a last will and testament. Everybody should have a last will and testament, but a will does not avoid probate. I had a situation once where we had the family come in after the last parent passed away. So it was mom and dad, and mom unfortunately predeceased dad, and dad passed away. And we had a letter from dad that accompanied the last will and testament about how he was so happy to give his estate to his children in equal shares, and how happy he was to have this last will and testament to avoid probate. He put it in a letter. Unfortunately, we had to probate the estate in Florida because a last will and testament alone is insufficient to avoid probate, and that individual's family ended up paying our firm approximately $15,000 or so to probate the estate, because all this individual had for his estate plan was a last will and testament. Now, it was a valid last will and testament. We got it admitted to probate, but we even had the testator's intent. The testator is a fancy word for the person who drafted the will. His original intent was to avoid probate. And he thought, even though he had a will, and it was a valid will in the state of Florida, that he was going to avoid probate, and everything else went smoothly with the estate. But that was another, whatever it was, 15 grand that the children could have split equally. But because I had to be hired and do the legal work and go to court and administer the estate and do the inventory and make sure all the creditors were paid, that we had to render a service and get compensated for it. But the number one mistake is thinking a will avoids probate. A last will and testament does not avoid probate, but having a last will and testament is much better than not having a last will and testament. The next mistake I found in going through all of my cases is families have issues where their person who passed away fails to update the documents. We again, I can only tell stories from personal experience. We had another issue at our firm where there was a valid last will and testament from the 1980s. I think it was 1986. Don't quote me on that. 1986, 88, something like that. And it was a valid will. It met all of the requirements under Florida law. Even though I don't know what the law was back then, but it was signed, it was notarized, it was witnessed. I don't know. I wasn't even licensed to practice law yet, and I wasn't even born in the 1980s. But it was a valid will. If you looked at it today, it looked like a valid will. It had this archaic text and different fonts and very thick paper, but it was a valid last will and testament from the 1980s. The issue was there was no will since then. And so that's 30, 40, almost 40 years that passed where this individual's wishes could have changed because they just passed away recently, early 2020s. That was what we had to stick to with the court. That was the last will and testament. Now, we got very lucky in this situation that all of the beneficiaries were able to enter into what we call a family agreement. And so even though the last will and testament said one thing, we were able to coordinate a different arrangement amongst the parties. However, should they not have agreed and not wanted to enter into a family agreement and a consent agreement regarding the assets of that estate, we would have had to follow the original intent of that document and probate it accordingly. So update your documents. We tell all of your clients your estate plan is something that you should revisit every 3 to 5 years and every time there is a significant change in circumstances. Did you win the lottery? Did you have another child? Did you have a grandchild? Did you come into money through your own inheritance? If there's ever a big change where money's coming in, money's going out, or family is being added, or you met the love of your life, perhaps you want to think about changing your estate plan so those who you love around you can benefit from your estate later. Because remember, estate planning is not about you. It's about your family and friends, those you care about, because you're gone. Whatever you believe happens when you pass away, at least in regards to your assets, as I see them as a practicing estate planning and probate attorney, there's no ghost, no soul, no third party individual who gets to designate where those assets go. That is your estate plan. And so update your documents. That's the second thing. So the first biggest mistake is thinking a last will and testament avoids probate. It does not. The second biggest mistake is not updating your documents every time there's a significant change in your life circumstances, or every 3 to 5 years, at least reviewing it. I'm not saying you need a new will every 5 years, but just sit down and review it. Is this what I want to do? Yes, put it back in the drawer. If not, contact someone to change your will. Now, the third biggest mistake, and this is huge, and it's, we only learn from life lessons, and it's really sad when this happens, is naming the wrong beneficiaries. Whether it's a simple spelling of the name wrong, or naming your estranged daughter, someone you fell out of comfort with. Again, we can only tell stories. Had a situation where a husband and wife did an estate plan, and the husband passed away, and the surviving spouse thought that she was going to receive everything. 99% of estate plans, that's what happens. When you pass away, it all goes to your spouse, and then when the spouse passes away, to the children in equal shares. That is the most common estate plan. In this situation, however, dad forgot to change the beneficiary designation, and he listed his estranged daughter from a previous marriage as the beneficiary of one of his bank accounts. We couldn't do anything. There was nothing we could do. The bank gave the money to the third-party beneficiary. He listed the beneficiary designation. There was nothing that we could do. Sure, we could have theoretically litigated over it and fought about it and, said that wasn't the testator's intent, but, the spouse opted not to do that for, practical reasons, because it would cost a small fortune. And especially given that she was likely going to lose. It was a valid beneficiary designation. You can list whoever you want as your beneficiary, but if you list the wrong beneficiary, you're in a world for trouble later. The fourth biggest mistake, number 4, is not dealing with your property. So in Florida, everybody knows about the Florida homestead. And homestead provides wonderful protection from creditors in regards to your homestead property. It also gives you tax benefits as your primary residence. But what people forget is your homestead property is subject to probate. Your property will pass through probate. Now, if you want to avoid probate, you need to ensure that you've set up some type of legal mechanism, such as a ladybird deed, to ensure that the property flows from you to whomever you want when you pass, and then avoids probate later. A ladybird deed will help you and your family avoid probate later, because that's what it is all about. The fifth mistake is forgetting about all of these other documents. So I like to say that a comprehensive estate plan has at least a last will and testament, a durable power of attorney, a healthcare surrogate, and a living will. If you want to add on the ladybird deed, great. That's an amazing add-on. But at the very basics, you have those 4 documents. And in Florida, these are 4 separate documents. Healthcare surrogate, living will, durable power of attorney, and last will and testament. Those are the big four in estate planning. Not having the other three, not having a durable power of attorney, a living will, or a healthcare surrogate forgets about the other half of getting old. We all hope, I hope, you hope, everyone hopes that we age gracefully, that we get into our 80s, our 90s, maybe we even breach 100 years old, and we get there smoothly. Maybe we'll get some bumps along the road. But what we forget is, as we age, not only do our bodies start to fail us, but oftentimes our minds. Alzheimer's, dementia, other forms of incapacity. And now, what happens when, through no control of your own, you no longer can take care of yourself? You no longer have more good days than bad. And the truth is, you might not even realize this is happening to you. But everybody around you realizes. They'll start to hear that same story 3 times, and you tell it like it's the first time every time. You start to forget dates. You start to miss doctor's appointments. You don't know what day of the week it is. You start to stop going out with friends. Stop wanting to socialize with family. And everyone around you sees that your mental health is becoming an issue, but you don't see that. And so the durable power of attorney and the healthcare surrogate deals with what happens to you when you lack capacity. Because if you don't have those documents, again, I can only tell you sad stories. Just had a situation recently where none of these documents were in place. The individual had good days and bad, but every time we went out to see them, it was a bad day. And now we have to move forward with guardianship. So rather than doing a cheap will, which costs a few $100s, a cheap power of attorney, a few $100s, a cheap living will, a few $100s, now they're spending thousands of dollars. And they'll probably end up spending tens of thousands of dollars to do a guardianship. And they'll get to be the guardian. They'll be the guardian because they have capacity, they want to take care of their spouse, so they're going to become the guardian, but at what cost? And so don't forget about the other picture when you start to age, is that you're not just going to pass away, but it is probable, and I hope it doesn't happen to you, but it's probable that as you age, your mental health will deteriorate. So let's briefly recap. I'll go through my big five. The big five mistakes in estate planning. Mistake number 1 is thinking a will, also known as a last will and testament, avoids probate. Here's the lesson. A last will and testament does not avoid probate. Having a last will and testament is very important. I have a last will and testament. It's better than not having one, but it does not avoid probate. Next is failing to update your estate planning documents. Anytime there is a major change in circumstances, or every 3 to 5 years, just take a look at your documents. You don't need a new will every 5 years. If someone tells you need a new will every 5 years, they're just trying to sell new wills and new will packets. That's not necessary. But you need to look at it. Is this what I want? Do I still love my wife? Did we get divorced? Oh my God, the amount of times people come in and say, oh, I forgot, you did a divorce for me. Do you want to do an updated estate plan? I said, yeah, we talked about that before. You said you didn't want to do it right now. You need to look at your major life changes, and you need to decide if you need a new estate plan. You might not. That's okay. You don't need to revise one. Like we talked about earlier in the video, we had a will from 40 years ago that was valid. But do you need to look at it? Absolutely. Mistake number 3, be very careful when you name beneficiaries that you are naming the correct beneficiaries. The biggest mistake I've seen is misspelling beneficiary names and naming improper beneficiaries because you just didn't think about it. Remember, you got to think about your estate plan every 3 to 5 years. Who did I list on my account? Is that still who I want to list? Number 4 is forgetting about your home. Florida provides great protections for your property. You have the homestead protection, which protects you against creditor claims. It'll provide you bankruptcy protection. It'll provide you tax benefits, but it will not avoid probate by itself. Consider a Lady Bird deed. And last but not least, and maybe I should have went through this one first because of how important it is forgetting about the other estate planning documents. Remember, a last will and testament is just one part of the big four. You have the last will and testament, the durable power of attorney, the living will, and the healthcare surrogate. Those four quarters make the dollar of terrible. That's terrible, but that's the comprehensive estate plan. Is those four documents, because we forget that as we age, we never want to plan for this. We don't want to plan, oh, when I get older, I'm going to have dementia. We hope that doesn't happen. But if it does, we want to have a plan in place. So thank you so much for listening today. I hope these five common mistakes, which ended up kind of being five estate planning lessons, really strike home so that you at least start thinking about your estate plan and what you need to do moving forward. Thank you so much.